Welcome to today's webinar on employment law. It is an update webinar, so we'll cover a number of topics. We've just opened the live room for attendees, so we will allow a few minutes for everyone to get logged in. As you're joining, sorry for getting this opened up a little bit late, but we will get started in just a couple of minutes and try to stay on schedule. We target this presentation for about 1 hour and go beyond that as necessary to answer questions that come in. So if you're just joining, you should hopefully be able to hear me, see the slide presentation, Spring 2021 Employment Law Update, COVID-19 and Beyond. There is a chat window where you will be able to enter any questions that you have. Again, we were a couple minutes late here in getting this launched for people to log in, so I apologize for that. We will get started in just a minute or two and stay on schedule of about an hour, subject to the questions that come in, as we like to stay around as long as possible to answer those. When we formally get started, I'll run through all of the logistical information. This is Spring 2021 Employment Law Update from Horton Law. I am Scott Horton. Hello there. Thanks for typing in the chat to let me know that that is working. Hopefully that also means that you can hear me. As far as I know, everything's going well from my end. If you do have any trouble during the presentation, the best suggestion is to, of course, you can type something in chat, but try closing other apps you might have on your device, as that could affect the performance of this webinar. And if otherwise that fails, you can try logging out and logging back in, and hopefully that will fix any problems you may have. Otherwise, again, I know we're a couple minutes late in getting this room open for people to join, so I'm going to go ahead and start with some of the preliminaries, and hopefully everyone else will have a chance to get logged in if they haven't already. We have a good number of people on, so I'm going to get started. Again, I'm Scott Horton of Horton Law. This is the Spring 2021 Employment Law Update, COVID-19 and Beyond. Our office is in Orchard Park, New York, outside of Buffalo. The presentation will address some New York issues specifically, but if by chance you are watching this and have an interest that's not specific to New York, don't fret. What I've done is structured this so the first half or so of the presentation addresses US or federal issues, which should apply generally to anyone with employees in the United States. And then the second half will get into any New York specific issues, primarily including the new marijuana legalization issue and the impact that that will have on the workplace, as well as covering some other leave issues that have developed over the last few months here in New York. As far as some of the technical issues, again, we go for about an hour, and then I hang around and answer any questions that come in through the chat window. You're free to ask and encouraged to ask any questions you have in chat when they come up, but understand that usually I will hold off on answering them until the end, unless it happens to be something that I see and can answer directly where I am speaking in the presentation. But I don't want you to forget the question, so type it in wherever you want. We won't have any problem getting back to it at the end of the presentation. The slides will be available to you by a link at the end of the presentation, and you will also get a follow-up email tomorrow that confirms your attendance if that helps you out for any accreditation or other purposes, and gives you another opportunity to link back to the slides if you need them. With that, I think we're going to get started. And again, I'm going to start with some of the federal law or nationwide questions and issues. Of course, sitting here in the spring of 2021, we'd be remiss if we didn't address COVID-19. At this stage, all of us have been dealing with COVID-19 and its implications in the workplace for over a year at this point, and I'm not going to try to rehash every possible issue, but the current pressing issue that's sort of a little bit new from where we were even a few months ago is the widespread availability in most places of the COVID-19 vaccine. Just thought it would help to orient us a little bit to note that at this point, there's still less than 25% of Americans who are fully vaccinated. That number is still including the children, most of whom are not eligible for vaccines at this point. However, on the other hand, nearly half of US adults have received at least one dose. So unless we're talking about the specific one-dose Johnson & Johnson vaccine, that includes some people who have one shot, but not the second shot that they need to be considered fully vaccinated. As I mentioned, we'll address New York specifically. A little bit more of the New York population has been fully vaccinated, 26% based on current data. But still right in line with the US estimate overall. The last point I want to make, because it might become relevant in a few things that are going to come up going forward in the presentation, is that the latest surveys, polls, and estimates suggest that 20 to 30% of Americans don't currently intend to get vaccinated. So those are the people that, for whatever various reasons, have decided that even if and when the vaccine is available to them, they are not going to receive it. Just want to briefly comment on the current implication, I guess you will, of having the vaccine. So labeled this slide protections and limitations. The idea being that if you're vaccinated, look above the yellow line on the slide. If you're vaccinated and you're asymptomatic and it's within 3 months since you've had your final dose of the vaccine, then you don't have to do things like quarantine if exposed to someone who has tested positive, or even if you yourself test positive. Again, it's critical that you're asymptomatic. So if someone has been fully vaccinated, but they're showing symptoms that could be associated with COVID-19, then that person should still be considered one who needs to quarantine, isolate, or take whatever other special precautions apply. The other important thing is, well, first of all, it takes 2 weeks after the final dose for you to be considered fully vaccinated, but then there's only a 3-month window so far where you're considered to be vaccinated, I guess is one way of looking at it. We are actually getting to the point now where there could be people who were fully vaccinated approximately or more than 3 months ago. So it'd be interesting if we start to see and hear some new guidance on that 3-month window, whether that gets expanded or just what it means. But that is a looming question of interest. Below the line, I just note that similarly, if you have someone who's tested positive for COVID-19, then they, after their initial symptoms pass and the quarantine period has elapsed, would also not need to re-quarantine generally based on another exposure. In other words, a family member or a close contact has been exposed recently and tested positive. If you've already tested positive and recovered from that COVID-19 in the last 3 months, then you're in essence considered to be in the same place as if you had had the vaccine. Still have to be asymptomatic. Okay, so there's just some brief notes to see how they kind of fit in the picture as we go forward. So where are we on vaccines from a legal standpoint affecting the workplace? The EEOC, the Equal Employment Opportunity Commission, has sort of taken the lead on this, the federal level, of explaining what are and aren't legal prohibitions, restrictions, and rights on employers and employees on this question. So while they're not the only agency or entity that might have an interest or be able to weigh in on this, they are one of the most influential ones who has in sort of a systematic way. According to the EEOC, which I know administers the employment discrimination laws at the federal level, so things like Title VII, race, age, sex, religion discrimination, and disability discrimination under the ADA, as well as some other statutes. They note, with respect to the ADA, that vaccination itself is not a medical examination. What does this mean? There are restrictions on when employers may or may not have their employees undergo a medical examination. So those do not generally apply to having your employees get vaccinated. If, for example, you wanted to actually provide vaccinations for your employees on site, that alone would not constitute submitting them to a medical examination, so you don't need to go through further analysis to determine whether that's okay, as you would for a medical examination. However, the rub on that is that the accompanying pre-screening questions that tend to be asked with vaccinations likely would be medical examinations, or at least medical inquiries. In other words, asking someone whether they have any allergies that might affect whether they can take the vaccination, or even if they've had any medical conditions recently that would be relevant to taking the vaccination. So in that situation, if you as an employer were somehow responsible for conducting that pre-screening through one of your employees, then you are wading into territory where the ADA may regulate what you can do. Supposing you probably set it up so it job related and consistent with business necessity to provide the vaccine and therefore ask the questions. The flip side of that would then be, once you get that information, it must be maintained confidential, and certainly adverse employment actions should not be made based on the information. That's one thing that EEOC has addressed. Another is that mandating proof of an employee's vaccination is not a disability-related inquiry. In other words, if you have an employee who, for whatever reason, has disclosed that they've been vaccinated, but it's necessary, or you choose to ask for confirmation of that, that is not a disability-related inquiry, which again would carry with it special consideration under the ADA. So you can do that pretty safely, as long as you don't probably discriminate between employees as to who you require it from and who you don't. The next step in that, however, is that asking why questions related to proof of vaccination could be problematic. In other words, if someone provides proof and you have reason to question it, inquiring as to where they got it or what circumstances, why they were at the hospital, stuff like that, could become a disability-related inquiry that may or may not be permissible under the circumstances. And the flip side of the analysis being that someone who says they can't prove that they've been vaccinated, or that says I have not been vaccinated, if they are asked why, then there is a substantial chance that their answer would be disability related or potentially religious related, in which case the inquiry becomes somewhat restricted based on the ADA, Title VII, or potentially another discrimination law. So imagine you ask somebody why they haven't been vaccinated, and they say that they've had some sort of medical condition that prevents them from being vaccinated. That was now a disability-related inquiry, arguably, and it may or may not have been job-related and consistent with business necessity. And even assuming it has, again, you'd have to keep that information confidential and both practically keep it confidential from people who might make decisions regarding that employee that are unrelated to the vaccine issue, and or hope that they don't somehow make decisions based on that disability related information that could lead to a disability discrimination claim. The one more huge issue that the EEOC has commented on is that of accommodations. So under the federal employment discrimination laws, employees have accommodation rights based both on disability and or religious beliefs. So most of you are probably well familiar with accommodating disabilities. Probably fewer of you, but still many of you are familiar with accommodating employees' religious beliefs. Those are the only protected categories under federal law that carry with them accommodation rights. Again, we're talking the reasonable accommodation without posing an undue hardship analysis that many of you are familiar with. If someone says, no, I have not been vaccinated and I'm not going to be vaccinated, and you're otherwise requiring similarly situated employees to be vaccinated, or it somehow affects job responsibilities or something along those lines, then it could become an issue if they say that they're not becoming vaccinated because of a medical condition or their religious beliefs. The key point on this, especially with religious beliefs, is that your ability to prove or disprove the belief is going to be difficult. Basically, the EEOC wants you to assume that if somebody says their opposition to the vaccine is based on their religious beliefs, you probably shouldn't question that further. The questions then become what accommodation is reasonable under the circumstances, which could range from you can sit at home without pay for some period of time until it's not critical to us that you've been vaccinated, perhaps in some circumstances, to you're going to continue to work, but you need to take additional precautions, work separated from other employees, have additional PPE available, or something like that. So I'm sure this is begging a few questions that we'll probably be getting back to. So just bear with me as we go through. But again, don't hesitate to type in any questions you have as we go throughout this presentation. One new prevailing issue in even the last couple of weeks and days is that of vaccine passports. So this is something that many of you will have heard of, probably by this name or something similar, or you will be hearing of in the days that come. A vaccine passport, despite the name, is not primarily focused on travel internationally, like a passport typically is. Passport here just refers to more of any certification mechanism that shows that someone has been vaccinated from COVID-19, or in some cases also reflects whether they have a recent, generally negative COVID test result. The world being what it is today, these vaccine passports are primarily in the form of a smartphone app that may have a QR code, for example, that someone can scan and find out either whether the person's been vaccinated or had a recent negative test. And the different passports that are being put out there work a little bit differently, but in some cases, for example, you wouldn't necessarily know whether the person was vaccinated or had a recent positive test. You might just know that one way or the other at that moment, they're not considered to be unprotected from COVID, for example. Maybe a better way to say that is at the moment they are considered to be protected against getting and hopefully transmitting COVID-19. By and large, these types of vaccine passports are primarily aimed at attending public events, ranging from large sporting events to museums and art and entertainment facilities, down to going to restaurants, stores, and other places open to the public. But they could be used for work generally. So the focus again would be, if you're going to use it to say who can come to a football game, that would apply to any attendees who are paid ticket buyers to come to the game, as well as the employees of the stadium, arena, or whatever for a sporting event, or anyone else who happened to have the right to come in. The way these are set up and intended to be used then can easily transition to really any workplace. And for example, New York has what they're calling the Excelsior Pass as their vaccine passport. There is guidance on their website that explains how any business could use their passport. Because this is primarily a smartphone app, the major pushback on vaccine passport so far has been privacy and security, so technological security issues, as well as just personal privacy concerns. The New York Excelsior Pass website has extensive technical information down to pretty specific details about what security measures are or aren't in place for Excelsior Pass. Obviously, states that are creating this are well aware of the privacy and security issues, so they're not just throwing something together. But again, anyone can reasonably question how secure anything is and whether their information could be hacked. For the most part, it doesn't seem that these vaccine passports are connecting that much personal information beyond things like name, perhaps date of birth, and their COVID vaccination or test status. So there's a limited amount of personal information available through the passport. But again, that is the pushback in one sense that people will always have with electronic data of a personal nature. Shifting a little bit away for now from the vaccine issue is a few slides, or going to be a few slides on the federal government under President Biden and how that may differ from the previous administration. There'll be more reference to COVID in this information as well, but just to set the picture more broadly, Marty Walsh is the new Secretary of Labor as of the last couple of weeks. He was a local laborers union president before becoming the mayor of Boston, which is the job he held before becoming the U.S. Secretary of Labor. Marty Walsh, as expected, has quickly gotten efforts underway to halt or roll back many Trump administration regulations and interpretations, and to do so as quickly as possible. Just in case anybody not entirely familiar, the U.S. Department of Labor has many sub-agencies, including things like OSHA, and it also oversees wage and hour issues like the Fair Labor Standards Act, the Family Medical Leave Act, and some labor-related reporting for unions and companies that use labor consultants for sort of union related matters. So there are several different aspects. I mean, many different aspects. That's just three of the most relevant ones for what we're talking about here. So there is widespread impact of a new Secretary of Labor changing policy in a different direction. The FLSA regulations from the Trump administration, generally speaking, could be summarized as being more employer friendly, less restriction, arguably fewer employee protections, and basically everything that may change under the new Secretary of Labor and new administration can be assumed to be going in the opposite direction toward greater restriction on employers, expansion of employee rights in the workplace. That's not surprising. That is the general trend between Republican and Democratic administrations. But every time the shift happens in recent years, going back the past couple of decades, it seems like the shifts from one direction to the other become even more pronounced. Another major federal agency with relevance to the workplace is the National Labor Relations Board. This is not part of the Department of Labor, although it has some relatively closely related subject matter. President Biden, on his first day in office, immediately fired the general counsel of the National Labor Relations Board. Peter Robb was not well loved by labor unions, understandably, based on the positions he took, which were more favorable to employers and business. The unique thing about this is that Peter Robb, like general counsels generally of the National Labor Relations Board, had a 5-year term that wasn't set to expire until later this year in November. And the tradition had been for an incoming president of a different party to allow the general counsel to finish their term. So by firing President Biden, by firing the general counsel, President Biden has prompted a big pushback from employers, including in National Labor Relations Board cases, arguing that he did not have the authority to do so. Those cases haven't been played out yet, but again, they're not surprising. It is a more or less novel situation for reasons that we're not going to waste time to get into here. So it will be interesting to see the outcome of that. In the meantime, however, employers probably can't sit around and wish or wonder that firing will be deemed inappropriate one way or the other. Eventually, the new general counsel will have authority to do whatever he or she may need to do. I say he or she because there's an acting general counsel who is the he in that equation, and there is a proposed new permanent appointment general counsel who's a woman. So right now, the acting general counsel has quickly taken up a more aggressive approach to prosecuting unfair labor practices, which is the name of most employer transgressions under the National Labor Relations Act. This National Labor Relations Act is the law that both allows employees in the private sector to form unions as well as engage in other concerted activity that may not involve being unionized, but still working together with other employees to improve their working conditions generally. So a lot of what they do deals with unions, but it's not necessary to be unionized to have to worry about what the National Labor Relations Board is up to. The general counsel is basically the chief prosecutor of the National Labor Relations Board, so that's why I say more aggressive prosecution is underway. The board itself, which ultimately would resolve any close cases of whether the National Labor Relations Act has been violated, consists of 5 board members in Washington, D.C. That is, say there's 5 seats. 4 of them are filled right now. 1 of them is open. There are 3 Republicans and 1 Democrat, all carryovers from the Trump administration. The next seat that comes open, again, these are 5-year terms, and there's been no effort by the president to try to undo that, will be in August. So in August, it will be down to 2 Republicans, 1 Democrat, and 2 unfilled seats, unless something happens between now and then. Ultimately, it's overwhelmingly likely the president will appoint 2 Democrats to those 2 seats, shifting the balance of the board to a Democratic majority, which will shift the National Labor Relations Board adjudicatory function to the same side of the spectrum as its prosecutorial function, meaning that outcomes from the agency starting late this year will be more employee and labor union friendly and less likely to side with employers in contested close cases. What is that likely to mean? For those of you who've been around long enough to remember the Obama era of the National Labor Relations Board, and especially the shifts from the prior precedents under the Obama era board, you will know that there were some pretty dramatic movement toward granting employees new rights, like, for example, the right to use their work email for personal either union or other concerted workplace activity. So basically, this was a restriction on what private employers could do with their own email systems, which was not very well received by industry at the time. The current ruling under the Trump administration did shift that back to say employers could generally prohibit employees from personal use of work email. The new board will once again shift that back in the other direction once Democrats take the majority and get back the case that allows them to make that decision. And there are numerous other examples of issues that will shift. This, for example, will mean a more expansive joint employer standard again, as another issue that's been volleying back and forth. This is particularly relevant in workplaces that involve temporary employees or staffing companies, or in franchised businesses where the corporate entity that owns a lot of the IP and sets various other practices may be or may not be considered the joint employer of the franchisee, who is the one that actually pays the employees and hires them and all that sort of thing. This can have implications in both the respects of who can and can't join a union or be represented by a union in a bargaining unit, as well as who can and can't be taken to task for other unfair labor practices, such as workplace policies that might be deemed to run afoul of the National Labor Relations Act, or disciplining or discharging employees who, for example, claim that they were fired because of their pro-union sentiments or activities. The other quite likely outcome of this policy shift will be faster union elections. The Obama era board put in rules that were known as quickie election rules. The Trump administration rolled that back, and there are rules pending now and being debated back and forth. There's kind of a lost cause. Eventually, again, when the Democrats get the majority, it would be quite likely that they will shift the union election rules to have elections conducted quicker. You can come up with a whole bunch of academic analysis on what's right, wrong, and different, better for policy or whatever other reasons. But basically what's going on here is the theory that faster elections are better for unions because they effectively have the element of surprise in filing for an election, and the more time between that filing and the actual election, the more time employers have to make their case to their employees why they don't need the union. Finally, as a general matter, this would be expected to lead to greater scrutiny of workplace policies, things like confidentiality policies and workplace conduct policies. One of the major startling decisions in the Obama era was when the board started telling employers that if they had a policy that says you must be respectful at all times, that's an unfair labor practice, on the theory that employees were allowed to take stances that might not be seen as so respectful towards their employer in an effort to improve their work conditions. So expect a major shift in these types of issues to the extent that you've ever dealt with them before. Pay attention if you haven't, if you're in the private sector, that is not a public government entity, because while we know how much the Obama era did to create new claims for employees, and we expect that to become the norm once again, it is possible that something will shift even further and we will be dealing with something new and even more dramatic than we've already seen in the past. Following right off of that is critical legislation that has been pending called the PRO Act. I'm honestly not looking at it right now, but assuming from recollection that this is something along the lines of promoting the right to organize act. I'm going to actually double check. Protecting the right to organize act. So again, I could come up with different keys there, but I've also, and the reason I'm focusing on that for a minute is I've seen folks on the other side opposed to this act call it the Pro-Labor Union Bosses Act. So here's the gist of it. It is multifaceted legislation that's aimed to protect workers and unions. There's no mistake that this is a pro-labor union piece of legislation, and it is expansive in the way it would change the National Labor Relations Act. On the whole, it would give employers more workers right to unionize in dealing with their employers. It would limit people who could be excluded as supervisors. It would expand the joint employer definition. It would do several things to cover more workers, independent contractors, and the like. So more people will be eligible to form unions and otherwise be protected by the National Labor Relations Act. It would do various things to restrict employers' ability to resist unionization. I want to get too much in the weeds on that one, but one of the key examples is something that unions refer to as captive audience speeches, where employers, since they're paying the employees to be at work for decades, have been allowed to bring their employees into a meeting at work in which the employer says, here's everything you should know about our company and the union and why we think that you should vote no to bringing the union in. Unions obviously don't like these meetings, claim that companies have an unfair advantage because they can bring all these people in while they're at work and make them attend such a meeting, and the union can't make anybody attend some off-site meeting that they host. What am I saying? I'm saying that the PRO Act would eliminate employers' ability to hold such a meeting. I mean, the important flip side of that is it doesn't prohibit unions from having voluntary off-site meetings, at which, for example, they may have raffles and prizes and free food and drink and all that sort of thing to try to entice employees to attend in the first place and potentially to support the union. It imposes significant new penalties on employers who violate the National Labor Relations Act. These are just more dramatic penalties than we've seen under any other legislation restricting the workplace, just to be honest. I mean, monetary penalties, fines, it's liquidated damages with punitive damages on top, like triple liquidated damages. I mean, it's everything you could think of from any other employment statute in way of penalties, and then we just like double it or expand it in some way, shape, or form. I'm being vague here because we could have a whole presentation on just this topic, but it is dramatic, and I don't think the labor community would dispute that it's dramatic. They would just argue that it's justified, which I'm not here to debate the policy point of it. I'm just letting you know how dramatic the shift would be. President Biden has expressed support for the PRO Act, including in his recently announced American Job Plans, his infrastructure proposal to bring back jobs by improving the nation's infrastructure. I'm not sure that anybody is opposed to improving the nation's infrastructure, but one repeated theme throughout his jobs plan is the focus on union jobs. Here's just one such statement. It has never been more important for us to invest in strengthening our infrastructure and competitiveness and in creating the good paying union jobs of the future. Note that for private employers, the president doesn't have the right to force unions upon anyone, not purporting to do that, but he is clearly expressing a belief that union jobs are good jobs and there should be more of them. That is definitely consistent with what the PRO Act seeks to accomplish. The Senate, the Democrats have a slim majority in the Senate. They have a larger, although decreasing, majority in the House of Representatives. They have and can again pass the PRO Act in the House of Representatives. The Senate is more complicated. because of their filibuster rules, they would need 60 senators to overcome a filibuster on the PRO Act. At the moment, they have 50 Democratic votes. One or two of them might be in question as to whether they would ultimately support the PRO Act. But there is zero chance that any of the Republican senators would support the PRO Act. So unless the filibuster goes by the wayside or they come up with some other unique and unexpected way to push this to a floor vote, it does not look like the PRO Act is going to pass anytime soon. But if the filibuster falls or falls in this respect, then there is the will of the Democratic Party to make this the law of the land. It's kind of as a transition between the general federal US issues and the couple specific New York developments that we're going to discuss. I want to comment a little bit on the status of employee claims. So overall, these federal agencies, the EEOC, the Department of Labor, the National Labor Relations Board, for reasons we've discussed, and others, will become more aggressive in outreach and enforcement under the Obama administration compared to the past 4 years under President Trump. So we could spend time going through various specific situations, but many of these agencies have already trained procedures, programs, interpretations, etc., that both enhance their effort to let employees know about their rights and the vigor with which the federal agencies will pursue their claims, and in some cases, the extent of damages that they will seek. Most recently, the Department of Labor just changed a policy that, in essence, will make it more likely that they will seek liquidated damages in unpaid wages, so minimum wage and overtime cases, just as a very recent, in the last few days, tangible example. But you could find them everywhere if you go looking. I mean, it is a sea change in that respect, not to say that the Trump administration was asleep at the wheel and not doing its job. It's just, again, a matter of how aggressively, to put it simply, it's going about it. Job displacement issues would always be expected to contribute to more claims by employees. People who are out of work are more likely to sue their former employers than people who are gainfully employed. For various reasons, they don't need the money as bad if they're working. They don't have as much time if they're working. They're not as upset if they're working. They're not stewing on whatever happened to them at their previous job if they're now working, etc. So for companies who have laid off significant numbers or even small numbers of employees during the pandemic, whether related to COVID or not, there may be greater likelihood of those employees coming back and filing some sort of claim against the company. And again, that's not COVID specific, other than to the extent in certain industries, especially, that COVID contributed to somewhat unprecedented, in cases, layoffs industry wide. There are many other COVID related issues that are already starting to prompt litigation from employees against their current or former employers. This ranges from sort of OSHA issues, safety and health issues. My employer's not doing what it should be doing, and I got COVID. I developed symptoms, or I haven't gotten COVID yet, but I'm afraid I will. Also could include the disability accommodation issues. It could include discrimination issues of any sort based on who is or isn't allowed to work from home, as the trend is to try to move back into the physical workplace. So there's many of those types of things. And now, as we were talking about a little bit more, there could be vaccination related issues. One of the big questions people are going to have is, should I mandate vaccinations among my employees, which I said is going to raise accommodation issues, which could lead to discrimination claims, and ultimately could lead to legal challenges as to whether mandatory vaccination is permissible or not. At this point, based on everything we know, there doesn't seem to be a particularly clear prohibition on mandatory vaccinations, but it's not the type of thing that has become such a prevalent societal issue in the past as it is now. So I have a little bit of data to sort of hammer this home. The EEOC every year puts out pretty extensive data on the charges of discrimination filed with that federal agency. In most states, you can file discrimination claims either with the EEOC or with a state agency. So this isn't all the discrimination claims that are filed in a year, but you can file an EEOC claim anywhere across the country. So at that level, you can see here that over the 8 years of the Obama administration, there was always at least 88,000 and usually over 90,000, at the peak close to 100,000 discrimination charges filed each year. At the other end, in the red, under the Trump administration, the number has declined each year over the last 4 years, now down to a much lower level of just under 70,000 claims in the fiscal year that ended last September. So what does this mean? I mean, be careful in interpreting data, but I think based on everything we know and experience and everything I've just said, it is fair to assume that there is some relationship between the administration's viewpoints and the number of discrimination charges that get filed in a given year. Showing the red versus the blue here, I guess the easy way to put it is there wouldn't be any reason to be surprised if this trend in the red under the Trump administration changes as we move into the Biden years. Again, this is not a case where the EEOC filing these charges. It's individuals going to the EEOC, but for whatever various reasons, employees may become more aware of the EEOC and the ability to file discrimination charges under a Democratic administration, and or they just may feel that they're going to get more out of the process, or there could be other factors involved. But I would just warn employers, HR folks, managers, owners, and the like, that on the whole, this is some statistical data to confirm what there's otherwise reason to believe, that you are more likely to have some form of employee dispute get to government agency level now than you were a year or so ago. Again, any questions as you have, but now I'm going to hit on the couple New York specific issues, including the really interesting one of recreational marijuana in just a moment. Just kind of as a recap, I don't want to spend too much time on this in this presentation. New York has really several paid leave issues going on in the last few months. So there was the statewide paid sick leave law that is now fully in effect as of January 1. This is the law that provides where employees at the largest companies may be able to get up to 56 hours of paid leave per year. You can front load it, or they can earn it throughout the course of the year. The very smallest employers don't have to pay the leave. They just have to give the time off. And, for some people, the max is 40 hours. Some it's 56 hours. There's a lot of details on that. Again, it's really a separate presentation. If you are not on top of your New York paid sick leave obligations at this point, then make sure you look into it and get on top of it. You need to have a written policy in place for practical reasons, or at least that's my recommendation. Just a quick caveat, if you are a public employer, so city, town, school district, government agency, then you're not subject to that paid sick leave law. But any private business with as few as one employee has to worry about it. The next New York specific leave issue is a note that there's a 2020 COVID quarantine leave law that took effect right at the beginning of the whole COVID pandemic last year, which says that, if an employee is on a mandatory quarantine, then they get off up to 2 weeks, in some cases with pay, again, based on employer size. That does cover both public and private sector workplaces. There are some interactions with the paid family leave program in some cases. Most of you probably have become familiar with that if you're in New York and have had any employees with COVID issues in the past year. In January, the New York Department of Labor issued a 2-page memo sort of looking document, really weird format for this type of thing, where they allegedly interpreted that law. I put here that they rewrote it because I think that's a fair assessment. That does things like says, well, it turns out you can actually have more than one of these 2-week quarantine leaves. You can actually have up to 3, but that's only if the second and third are based on a positive test. And then it also creates this interesting, apparently mandatory paid leave that says that if an employer won't let somebody return to work because of concerns about them having or contracting COVID, then the employer has to pay for that leave until they either return them to work or they become subject to a mandatory quarantine order, in which case they may then have to pay them under the law itself, or may not if they've already exhausted their time. So I just want to let everybody know that is another kind of development that's still up in the air. They just threw this out on the website. A lot of people don't think they had the right to interpret the law in this way, but know that there's any more development on it as of this moment. Finally, New York just recently has put out another law that said all employees are entitled to paid leave of up to 4 hours per COVID-19 vaccine injection. So if you get the Johnson & Johnson shot, you get off for the one shot. The others, you get off twice. Paid leave of up to 4 hours. It doesn't mean you can go to the pharmacy next to your workplace that takes you, 30 minutes to walk next door, get the shot, and then come back and take 4 hours off. It should actually be the time it takes you, although admittedly that's going to be hard for many employers to enforce in some situations. Who knows what traffic is going to be like that day. But it doesn't seem to require too much advance notice. An employee who says, I have vaccine appointment tomorrow, probably is entitled to get off with pay. And that is for all employees in the state, regardless of size of the workplace or the number of, whether it's public sector or private sector. Okay, so here is the big new development as of about 2 weeks ago in New York, the passage of the Marijuana Regulation and Taxation Act. If you look at the title here, yes, there's an H in marijuana. That is the way the law is written. There is a reason for it, even though the overwhelming prevalent usage is marijuana with a J. Uh, Laws for many years have been written with marijuana being spelled with an H. I'm not going to waste time to get into the explanation, but suffice it to note that the Marijuana with an H Regulation and Taxation Act uses both spellings, and for operative purposes, finally just says, you know what we're going to do? We're going to call this cannabis. So, if you want to get more technical, we're going to talk about cannabis issues here than marijuana, and I'm not worried about the difference or similarity between the two. So this was signed by the governor March 31, 2021, with a lot of the elements effective immediately. It legalizes recreational marijuana use generally with some limits. It does add specific protections for employees who use marijuana outside of work, which we're going to talk about. And there is still, as ever, the question of, well, does it matter that marijuana is still illegal under federal law? So all of this description of what's lawful, again, this is according to New York State, in New York State, and under New York State law. Marijuana is still a controlled substance at the federal level. Take your chances with the FBI or the whatever other federal agencies might think that you're doing something illegal, the DEA, etc. These are now lawful activities in New York at present, as of the end of March, for people who are 21 and older. You can purchase, display, possess, obtain, transport up to 3 ounces of cannabis and up to 24 grams of concentrated cannabis. Again, I'm not going to get into the really technical things. So you can have a little bit of marijuana on your person. You can buy it. You can transport it. You can even give it to another person as long as they don't pay you for it. And as long as they're over 21, you can smoke it. You can use it, whatever that means. You can ingest it. You can consume it. Unless it's otherwise protected by or prohibited by state law. That means things like you can't just do it in a public restaurant or store or something like that. The places where you can't smoke, you also can't generally use cannabis. You can have cannabis paraphernalia the same way you can have cannabis. And you can assist another person 21 years of age or older to do any of these other things that you can do as a person 21 years or older in New York. The one thing you can't do at this point in New York is buy marijuana legally. So somehow you can get it. You could legally buy it in another state, then it becomes problematic when you cross state lines because the federal government certainly wouldn't like that. Or at least the laws on the books at the federal level wouldn't agree with that practice. You can't steal it legally, obviously. You also can't grow it, although you will be able to at some point in the future once that provision of the law takes effect. Anyway, somebody is smoking, using, possessing a small enough amount of marijuana or other cannabis product, they are not breaking New York law. What does that mean vis-a-vis the workplace? Section 201D of the New York labor law, which has been on the books for a couple decades now, protects employees' off-duty use of lawful consumable products. Historically, this has primarily meant alcohol and tobacco. Some would consider this the smokers' rights law, and there was a lobby for it in that sense. So you can't fire employees who smoke outside of work. Well, now you cannot do that for employees who use cannabis either. The law just basically says consumable products, including, quote, cannabis in accordance with state law. seems to be a direct effort to acknowledge that um, cannabis is legal under state law. So as long as you're following state law, you're okay. There is still that ambiguous question of what about the fact that it's illegal under federal law? But there's no doubt that the New York legislature has enacted this law assuming that it's going to protect people in New York as of now to use cannabis outside of work and not lose their jobs. There are restrictions. Again, it has to be outside of work hours. It also has to be off the employer's premises, and it has to be without the use of the employer's equipment or other property. If you have a company car, you can't smoke it in the car. Actually, you can't smoke marijuana in New York in a car anyway. That is one of the specific restrictions. But whatever. So if you're not using any company equipment, you're off the clock and you're off premises, then you have protections. Protections are not absolute. There are exceptions. Employer could take action against the employee where the actions are required by state or federal law. There are some industries regulated in certain ways that might prohibit the use of marijuana. Truck drivers, for example, probably would have limitations on when they can use marijuana under federal law that would have to be analyzed. Employee does not have a right to be impaired by the use of cannabis. So you can't have, or if you have someone who is impaired while at work, then you could take action against them based on the impairment. However, it gets complicated to figure out what impairment is, which I'll get to in a minute. Again, this is pretty much our last topic, so we're just going to wrap this up and take questions. So if you have any, go ahead and start typing those in. The other one is the employer's actions would require such employer to commit any act that would cause the employer to be in violation of a federal law or would result in the loss of a federal contract or federal funding. This is sort of the obligatory throw in that says, yeah, we realize marijuana is still legal or illegal under federal law. So if federal law forces you to do one thing regarding marijuana, then, we're not saying you can't do it. The real problem with that is there's not very much that federal law requires of employers vis-a-vis marijuana. There are drug testing requirements in the transportation industry that I mentioned that probably would fall into this category. For the most part, I'm not aware of anything else at the federal level that clearly says you can't have employees who smoke marijuana working for you. Let's touch quickly, though, on the impairment question because the law goes further to explain that to be considered impaired by marijuana, the employee has to manifest specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job, position, or such specific articulable symptoms interfere with an employee's obligations to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. Okay, well, what does this mean? Unfortunately, the big problem is it's going to be hard to determine objectively whether someone is impaired by marijuana. It's kind of like evaluating whether they're impaired by smoking a cigarette. Is it possible? Probably, but you can't really test for it. So drug testing becomes a problem. There's really no sense unless you're required by federal law to do it to test for marijuana in a pre-employment situation because you're not going to be able to deny somebody a job based on the fact that they have smoked marijuana before they worked for you. The next drug testing scenario would be during the work. We want to know you messed something up. Were you impaired at the time? Well, even assuming you can conduct the drug test very contemporaneous with whichever they did wrong, The fact that they're going to fail the drug test is not going to really get you anywhere on marijuana now, because all they have to say is, but I smoked it last week or last night at home. The testing is not generally going to show whether they were impaired while they were at work. It's just going to show whether they have relatively recently been exposed to marijuana, and the law says they have the right to have been exposed to marijuana to use it as they please, as long as they're not at work during work hours or using your equipment. So that's a problem. You'll have to rely on, again, articulable symptoms, visible symptoms that you can argue and constitute marijuana impairment. There is the Drug-Free Workplace Act, which is a federal law that requires some federal grant and contract recipients to maintain a drug-free workplace. It sounds like that's a sort of exception to these protections. However, that Drug-Free Workplace Act does not say you cannot have employees who smoke marijuana, especially not ones who do it outside of work. It just says people shouldn't be using marijuana or any other drugs at work, selling it at work, possessing it at work, those types of things. And the only further specific thing is it says you should have penalties for people who violate your policies. It doesn't say you have to fire people or can't employ people who bring marijuana to work. It just says you have to have some sort of penalty, if you want to call it that. Consequence, I guess, is a better word, which could theoretically include telling them not to bring the marijuana to work again. So I'm not sure just saying you're subject to the Drug-Free Workplace Act is enough to get you an exception from having to employ people with marijuana. My best guess is it's probably not, but I suppose the legal question and the possible challenge is still out there. Finally, just review your drug testing policies, assuming you have them in place. See whether they specifically reference marijuana. If not, then you might not need to change anything. If they do, however, then you may need to take that out or address it differently. Let me just answer this question because it's right here. Can you use reasonable suspicion rules like alcohol to test the person for impairment? I mean, you can. It's just a question of whether you can determine impairment. The distinction with alcohol is there's a level of alcohol in the blood at which impairment can be presumed. My understanding and experience is, generally speaking, the same doesn't apply for marijuana. Either there is marijuana or there's not, but you can't really test for the contemporaneous, say blood alcohol level of marijuana and then reach a conclusion of impairment. So yes, you could have reasonable suspicion, I guess, but you probably couldn't rely on the results. But I suppose some could argue that means you can't do the test in the first place. It does seem, however, that one factor in whether somebody was impaired would be whether they had marijuana in their system. I suppose you could take it to the extreme, not even extreme, but the next level of there's really no reason to drug test somebody for marijuana if they flat out acknowledge that they've recently used marijuana. You go up to somebody and say, we think you're under the influence of marijuana, and they say, oh, well, I smoked last night, but I'm fine now. Again, I'm not an expert on the science, but I don't think right now there's a test you could send them for that's going to show you any difference between they smoked it last night and they smoked it 5 minutes ago. And therefore, it's not going to tell you whether they were impaired 5 minutes ago when you saw them at work or not. That's going to be developed. I mean, that the state, as part of the legislation, actually is looking into things like how we can chemically measure impairment, but I don't think that is widespread right now is something that is feasible, So, all right. with that all being said, I am going to just shift to questions. Thanks. I know we ran a little over, but I hope everybody found this useful. Again, if you want to stay up to date, we do these webinars close to monthly on various topics. The best way to get the most immediate information that we have on labor and employment law developments is through our LinkedIn page. We have a blog on the website as well, and send out a monthly email newsletter with updates, but some things we will post in the moment on LinkedIn. All of our blog posts get posted to the page. So Horton Law on LinkedIn if you want as quick of updates as we have on major issues as we see them. I will answer any more questions. There's one or two still to get to in the queue, but if you have any, type them in now. And while you are thinking about that, I'm going to post the link to the slides. So you should now have a pop-up coming up that shows you how you can download the slides. If you have any problem with that or don't feel like doing it right now, remember that as long as you were registered with the correct email address, you will get an email tomorrow confirming your attendance and with a link to the slides that way as well. One other question that I saw come in earlier about vaccinations. If an employee is vaccinated and suffers side effects for a day, is this day off covered under the New York State paid vaccine law? No. The law is very specifically limited to up to 4 hours off to go get the needle stuck in your arm. Whatever happens after you get the needle stuck in your arm shouldn't affect your leave under that law. That person presumably can take time off if they have it available under the New York State paid sick leave law. But no, it doesn't extend their time. I suppose there's an argument that it extends the time. Let's say it reasonably is going to take someone 2 hours to go get the vaccination. And as they're driving back to work at the end of those 2 hours, they don't feel well, need to pull over, stop for half an hour, get a sandwich, and they end up being out 3.5 hours instead of the 2 hours you thought it was going to take. Yeah, I suppose I can make an argument then that they get paid for that whole time. But otherwise, if the side effects arise later, it's not going to implicate any leave under that paid vaccine leave law. It is going to rely on other available forms of leave as may apply. And I do think the New York paid sick leave would be available in that situation if they have it. Yeah, but on the other note on that, in case it's not clear, the 4 hours for each injection does not count against the New York paid sick leave. So that is an additional leave on top of the New York paid sick leave, as is the COVID quarantine leave for employees who are still getting eligible for that. You've been told you have to stay home because you tested positive or were exposed to COVID-19. You have to be off a week. You may have the right to get paid for that week based on the size of your employer and whether you previously used such leave. And that pay is not going to count against your available paid sick leave either. So that is all the questions I see at this point. If you have any other questions that you're still typing in, maybe try to hit enter and then finish the question separately so I know the questions coming in. Otherwise, I'm going to move to wrapping up here very quickly. Again, you can download the slides now. You'll get the slides followed up by email. We will have more webinars, so if this happens to be the first one you've signed up for, you can look out again, and they come about monthly. If you are registered, you will get an email going forward, letting you know about our new webinars. Of course, you can always opt out of that at any time, unsubscribe and stop getting them. But if you're interested in this one, we hope that you might be interested in some others. I don't see any more questions coming in at the moment. So unless something pops up right now, then I'm going to just go ahead and thank everyone for hanging on a few minutes longer than the hour we were expecting to go, and appreciate your interest and hope that this information has been helpful, and that despite all the complications and difficult things going on in the world, you have a nice day, and wish you luck in dealing with these matters going forward.